Next week, the result of Ballot Measure 3196 will be decided by popular vote. Ballot Measure 3196, better known as the Second Amendment Preservation Ordinance, is an initiative on our ballots that would allow the sheriff to make judgment calls on the constitutionality of gun laws he is asked to enforce. The ordinance also threatens organizations that do enforce gun laws, seen as contradicting the Second Amendment, as it was originally understood, with fines of up to $4,000. Several weeks ago, we talked to Mr. Ken Wisdom, one of the organizers of the ordinance, about why it's important.
The populace on the east side of the state is minute compared to the populace on the west side. And so we here don't have the voting power, I guess that you could say, that the west side does. And we live by a different way of life, I guess. You know, we don't have the amenities and everything that they do in those populated areas. And so I feel it's really important for us to preserve our rights here because we use them every day. Out here hunting, it's a livelihood to a lot. And so if you take that right away, you're taking that livelihood away from them also.
But can a sheriff make a judgment about the constitutionality of a gun law? Is he really equipped to make that kind of an interpretation? And even if he is, can a local sheriff's interpretation override state and federal laws? Well, we asked local lawyer Bruce Anderson what he thought, and he said he's skeptical.
Should Union County expand constitutional definition of firearms and prohibit enforcement of laws that regulate their manufacture, sale, and possession? Well, that's kind of a two-part question. I'm not aware of any legal basis for a county expanding or contracting the constitutional definitions of anything. Constitutional definitions are typically not left to the county sheriff, or even the county commissioners, or even the county attorney, or even the district attorney for the county. So there's just a number of structural mechanics difficulties with the thrust of this, trying to, I think, ask the voters to approve something that may not be possible to achieve. So the idea that a local government, a county government, could somehow empower and require a county sheriff with no legal training and without really the authority to be a judge of anything, to somehow put that burden on Boyd Rasmussen or anyone like him in any of the other counties. I think it's maybe a well-intended idea that we want to stand for the Second Amendment right to bear arms, and there's absolutely nothing wrong with that concept, but I think this ordinance is fundamentally flawed.
Now, Bruce cited what's called the Supremacy Clause in the United States Constitution. The Supremacy Clause says that essentially a state ballot can't contradict a federal ballot and a municipal law can't contradict a state one. It's a hierarchy, he said, and for this reason, he's skeptical of the bill's ability to stand up in court.
Ideas about an informed citizenry, to just check a box yes or no, or flip a coin sounds good or doesn't sound quite right. I think there's way too little information about this question on our ballot for people in an informed and reasoned sort of way to say sure or even absolutely not. Can you imagine? This is guaranteed to create litigation, and the cost of the county defending litigation by people who feel like this ordinance just doesn't fit the pattern of how laws are enacted and interpreted. We have in our Oregon statute, in the very chapter that this initiative petition was filed, a reference to the courts will be the ones that have to interpret this to see whether it does or doesn't pass muster, constitutionally speaking. And I would say that this is a guaranteed lawsuit waiting to happen.
Now, not wanting to stop there, I posed Bruce's questions to attorney Wayne Hicks of Josephine County. Josephine County passed a similar preservation ordinance to Union County's iteration that's currently up to vote. And Hicks was involved in the writing of that piece of litigation. And he said he believes that the bill can stand up to both of these objections. Hicks said that the bill doesn't try to regulate gun laws. Instead, it regulates a county budget. Essentially, it says that a county won't fund organizations that try to enforce unconstitutional gun laws. Laws aren't the county's jurisdiction, but its budget is, he said. And as for the sheriff's ability to interpret the Constitution, Hicks cited a court case in 1996 called Plintz versus the United States. In Plintz versus the United States, the Supreme Court ruled that the US government couldn't enlist local sheriffs to enforce a mandatory gun registration requirement that was set down by the Brady Act. This sets precedence, Hicks said, that the sheriff, or chief law enforcement officer, can stand up in certain situations to federal requirements for enforcing gun laws.
A couple of other things to note about the measure. According to Hicks, in the Josephine County iteration of the measure, it listed out specific infractions that were considered unconstitutional and could be subject to fines. That's specific gun rights that are, in the view of the county, unconstitutional. Those specifics were stripped out in the crafting of subsequent measures, according to Rob Taylor, a proponent of a similar measure in Coos County.
When I wonder about state initiatives, I rely on my voter's pamphlet to tell me that this is the measure. There's a summary, then there's actually the text of the proposed constitutional amendment or statutory amendment, and then all of the pros and cons, people in favor of and opposed to. You don't really get any context or any explanatory information, including the text of the actual ordinance that we're asked to approve or discourage with our vote.
If you want to learn more about the bill, you can find it in its entirety posted to La Grande Alive's Facebook page. This story was brought to you by